Welcome everyone to this launch of our Legal Mobilization Platform. We're very happy to have you all here today. Before I start with some words about what the Legal Mobilization Platform is and what it does, I want to acknowledge that we would not be here without the support of Concordia, who has provided us with the venue for today, as well as Leiden, Delft, Erasmus Universities, and our hosts, the International Institute of Social Studies and the University of Amsterdam. My name is Rana Kuseri, and I'm the coordinator of the Legal Mobilization Platform. I started in September, and it has been a really enjoyable ride from the beginning. I'd like to tell you all a little bit about what the platform is and how it differs from a regular academic platform. So the past year, I spent some time actually working at a regular academic platform, and some of you might have some experience with this. A regular academic platform might host workshops, meetings, book discussions, but sometimes we really miss the connection between society and academia and really having that impact. So what we do with the Legal Mobilization Platform is we take the mold of an academic platform and we completely break it. So we try to be a non-hierarchical platform, which is sometimes a difficult idea for some people in academia to grasp. We try to be anti-patriarchal, very inclusive, and these are things that we will keep working on throughout the course of our existence. Our goals are ultimately moving together and exploring the potential of legal mobilization as we try to achieve socio-economic, racial, and climate justice. Now, these are quite ambitious goals, but we think they're super important, and we think that the combined efforts of all our partners will help us to achieve this justice. We will do this through connecting our partners, inspiring them, and also reflecting together on the work that we do. It's also a critical space, meaning that we are not shy from offering critiques on our partners and the work that they do, but we do this in a kind way and in a considerate way. I'd also like to talk about who the platform is. So first of all, by being here, you are all actually members of the platform. We are the Legal Mobilization Platform together. We also have a series of, actually a very large consortium, it's growing, of international partners. We have partners in Geneva, we have partners in South Africa, many across the Netherlands, and many of them are actually here today. If you would like to become a partner of the platform, you can join us online on our website. It's iss.nl/LMP. And we also have our secretariat, so that's me. Our steering committee, Jeff Handmaker, if you want to raise your hand, say hello. Margareta Rinke Singh, she's also a member of our steering committee. And our advisory board, Jackie Dugard, Milun Kotari, Gloria Wecker, and Ambrina Manji, who's the moderator for today. I'll be handing you over to her very capable hands, and I hope you enjoy the program today.
Good afternoon, everybody, and good afternoon to those of you who are joining us online, and thank you to everyone who's able to be here in person today. Rana, for your introduction to the platform, for the magic that you've done in making it possible for us to be in this venue today. It's a wonderful space, as you can all see, and it's an excellent example, I think, of how it's possible to move outside of our normal spaces, to move outside of our normal academic spaces that we become far too used to bring our work into conversation with wider alliances and colleagues and peers. I completely agree with you that what we're trying to do with the platform is to break the mold, and it's very clear how much, in particular, Rana has shaped the way that the platform is working intellectually already at this very early stage. So we very much hope that today's event and then future events will be a way to provide space for each of us to reflect together and to think about how we might want to do things differently. So without further ado, I'm really delighted to call on the first three panelists of the first of this afternoon's conversations, conceptualizing climate justice, to join me up on the stage, and we'll get going with our discussion. We've asked colleagues this afternoon to reflect on a number of questions relating to conceptualizing climate justice. So the question for us is really what might climate justice look like? How do we think about it? What sort of shape would we want to give it? And then what tools in particular are at our disposal, and how do we make decisions about how we use those tools and when? And how do we make sure that the tools that we do have, or the tools that we would wish to create, are effective? And in particular, how do we think about intersection of those intergenerational justice? And I say this, I ask this question as someone who's based in Wales, because Wales is the first country in the world to have a Future Generations Act, which we're very proud, but also very watchful about the possibilities of such legislation. So to start with, then, Margareta. Many of you will know Margareta. Margareta's Associate Professor of Sustainability Law. Oh yeah, can you hear me better? Excuse me. Margareta's Associate Professor of Sustainability Law at the University of Amsterdam, and also a member of the Legal Mobilization Platform Steering Committee. Her research addresses the role of law in sustainable development challenges, particularly focusing on climate change and human rights. And before joining the University of Amsterdam, she was an associate professor at Leiden. She has a particular interest in work in the South Pacific, and she has produced or published papers and chapters, peer-reviewed articles on international law and in a number of interdisciplinary journals. So to begin with you, Margaret, if you want to make some comments, and then we'll move on to the other members of the panel.
Yeah, it's so great to be here. Thank you so much for your remarks and for the kind introduction. And many thanks also to you, Rana, for your tireless efforts to make this this event today possible. Really, we cannot possibly begin to explain how hard Rana has worked and how critical her efforts have been to us being able to be here today and to running this platform. So thank you very much, Rana, and thanks to all of you. It's a bit difficult to speak here in this setup, because really it's nice and it's non-academic and it's kind of glossy, but the practical thing is that we are here in the spotlight. We don't see your faces, which is really a pity. And I would also have so very much liked to see the online participants. I know that a number of incredible lawyers, activists, academics from around the world are actually joining us this afternoon, from other time zones, other parts of the day. So I will keep it very short, because there's somebody I would immediately like to invite to speak if we indeed manage to get her to join us today. So on climate justice, conceptually, what is it? It is something that shouldn't be defined from an ivory tower or from behind a desk. What is clear is what it's not. It's not a zero-sum game, and it is also not a standalone justice question. It is a justice question that is intertwined with any other justice question under the sun. Basically, climate change, the climate crisis as a problem is very much intertwined with existing problems, all with very severe justice dimensions. It must be seen in a historical perspective, looking at past injustices, colonialism, extractivism, violence against indigenous peoples, against women, against other marginalized and disadvantaged groups, and only a perspective that really looks at these structural and historical injustices can have a chance at promoting something that you may call climate justice. And blindness for any of these existing injustices could undermine climate justice. And that is then sounds a bit theoretical, but of course we see this in practice also in attempts to address climate change through the law, through legal mobilization. We see that, for example, in some cases, a very narrow understanding of climate justice that, for example, only looks at the future, only looks at rights of future generations, and then very often a very small subsection of future generations, and that is very often then territorially defined. So we look at our children and grandchildren in privileged parts of the world as the beneficiaries of rights, for example, without looking at people elsewhere who already suffer the consequences of climate change, who will suffer even more severe consequences in the future. We see that cases are sometimes litigated with this narrow focus, resulting in judgments with this narrow focus, which then, if you read them very carefully, are actually, and you can say, an insult to climate justice, because courts in the global north, for example, seem to care only about the rights of people within the territory in question. There are also judgments coming out mainly in the global south from courts that are very inspiring and that put forward conceptions of climate justice that have great value both legally and also in terms of shaping a global discourse. So, for example, the Pakistani and Indian courts have spoken about climate justice as having an intergenerational dimension, but also a very important component of solidarity, global solidarity, whereby existing justices need to be corrected. And there is accountability, but in a way that takes into account the different contributions of different actors to the root causes of the problem. I'll stop here, but I would very much like to hear if Zelda from the Philippines is with us. She is online, because it would be such a treat, I think, for all of us to be able to hear Zelda, because Zelda is a deeply respected colleague and friend from the Philippines who has led the efforts to bring one of the most incredible historical legal mobilization initiatives against the carbon majors, the big culprits, really, if you want to talk about the climate crisis, before the Commission of Human Rights of the Philippines, to try and hold them accountable for losses and damages already suffered in the Philippines, including human rights violations. And so this initiative involved victims and descendants of victims of Typhoon Haiyan or Yolanda that struck the Philippines in 2013, which was a terrible disaster that caused tremendous suffering. And Zelda has worked with communities and with local organizations to try and bring this historic case, which resulted in a landmark report from the commission that was launched last year after many years of investigations, hearings, written submissions, expert submissions involving lawyers and activists and experts from the Philippines, but also from abroad. And Zelda, I think we can really say that this case would not have been brought without Zelda. She was very much one of the visionaries behind this initiative. So when we speak about climate justice, I think there are many people in the world who have something to say about it, but what Zelda has to say will be particularly interesting and valuable for us, I think, to hear. And Zelda, I'm so sorry to put you on the spot. I don't know if she's not responding. Yeah, sure. Okay, I'll hand over.
Thank you so much for those comments. I think it's really important to begin by urging us to historicize our understanding of what climate justice might be, to think about the future, but also to be thinking about past wrongs and the structures that that have been left to us as a result of past actions and inactions. Really important, I think, also to point out that our understandings of who future generations are has been limited territorially. Absolutely, that we've been too comfortable with the idea of externalizing harms and costs and not thinking about future generations globally. I think that's important. Thank you so much for pointing us to the key judgments in Pakistan and India, to raising with us. I hope we'll be able to hear from Zelda in due course. I think that's really very important. If we move on until we know that Zelda will speak to us, Misha, I'm really pleased to introduce you. Misha is an assistant professor of public international law at Leiden. Her research focuses on human rights law and with a specific focus, I'm thrilled to say, on human rights law in Africa, on regional and continental courts and tribunals, and in particular on African perspectives on international law. So Misha, I'm very much hoping that you'll build on some of the conversation that we've already started to have, and perhaps from an African perspective in particular.
Thank you so much. So when I was invited to speak on this panel, I was a little bit unsure what I was going to contribute, because obviously Margareta is an expert on climate justice, and climate is in brackets, and Obiozo is an expert on perceptions of justice by communities, and I'm not an expert on either of those things. So what I look at in my work is basically how courts function and what they do. And I look specifically at the moment at the African Court on Human and People's Rights, which has jurisdiction over both human rights cases, of course, everything that's included in the African Charter and human and people's rights, but also actually has taken up jurisdiction on issues related to the environment. So it's quite an interesting forum when it comes to questions around climate justice, which are indeed, they touch on different topics, including human rights, but also environmental rights. But what I've noticed in my work is that quite often when I talk about the court and I talk about the work of the court, there's a lot of either misunderstanding about what it does, or people simply don't know that it exists. And so when we look at the second question that's posed on this panel, which is what tools do we have? And the third question is basically related to their effectiveness. If we don't know that we have these tools, then we can't use them, and they certainly won't be effective. That said, the African Court, like other human rights courts and any legal structure, is in no way perfect. There's a lot of things that can be said about perhaps how it should change and how these legal structures should accommodate the needs, our justice needs, more accurately. And so the question that I want to add to the panel is, how do we want to change these legal structures? It's not just what kinds of visions of justice do we want and do we need, but how do we make them a reality? And especially in terms of legal structures, not that that's the only way to achieve the climate justice or other justice aims that we might have, but they're certainly one of the most important and most powerful tools at our disposal. And within that, I think one of the things that I've encountered, an attitude that I've encountered, and I don't know if this is something that's shared by the people on the ground working on these issues, and I'd very much like to hear from the audience and people who, the NGOs and the individuals taking up these kinds of questions, is that there's generally, at least in the academic sense, a perception that due to democratic backsliding domestically, where states are moving away from protecting rights, whether they be human rights, environmental, or otherwise, and because we have backlash against human rights accountability at the international level, any sense of change is seen with a lot of skepticism, because it always somehow implies that we would lose more than we would gain. So we kind of tinker around the edges. We might adopt an extra treaty, or we have a little protocol, or we add an article to our constitution, but we don't fundamentally rethink what we have and whether or not it's really working for us. Because if we did, the change would be for the negative rather than positive. And I don't know to what extent this is maybe just too pessimistic. In my current work, I look at why states give the African court jurisdiction for individuals to go to it and use it to make their rights claims. And you would think, well, why would states ever do that? And yet they do. So perhaps that pessimism is somewhat overblown. Perhaps it's not, and it depends on the context. But one of the things that I think, one of the reasons I think we need to think about this is especially around effectiveness. And if I look at, for example, the way that the question was phrased on this panel about intersectionality and intergenerational justice, I mean, at the African court, we don't even have gender parity when it comes to applications. So if you look at the number of applications, how many are submitted by women and how many are submitted by men, the number of applications submitted by women is so low that it's basically negligible. So if we can't even get women to understand that they are allowed to use this platform to claim their rights, how can we even take it to that next step of thinking about intersectionality and intergenerational types of justice? So in our conversation, I hope that we don't just think about what we want, but also how we want to get there. Thank you.
Thank you so much, Misha. Your comments raised a number of questions for me about what are, I mean, if we were to draw attention to the fact these possibilities exist. So the African court isn't as well known, absolutely, as it should be. But what are the ways in for us? Is there something you could suggest to kind of elaborate on that point about what are the ways for us into the court? So are you thinking of things like using the fact that you can be joined as an amicus, or what are the existing strategies that we might that are open to us that we're just simply not using as effectively as we might?
Do you want me to answer?
Yeah.
Okay, so that's exactly brilliant. This, I think, is exactly what a lot of people struggle with, right? So there are different ways in which a court can be accessed. The number one way for any international court is interstate procedures. So you could, for example, if your state, a neighboring state is doing something, let's say, Zambia is polluting Lake Tanganyika, and Tanzania wants to say something about that because it affects Tanzanian citizens. Not a problem. You can lobby your state to do that on your behalf. That's sort of the classic way that would work. In addition to that, you can have direct access if your state has submitted a special declaration. Unfortunately, very few African states have actually opted to do so, and 4 of them have since withdrawn those special declarations. But if there was more pressure on states domestically to actually do that, so that individuals can make rights claims, I think that would really fundamentally change the nature of also the types of cases that go to the court, which is now quite limited mostly to fair trial, whereas it has really exciting potential around, for example, environmental claims making, and has been used, as Obios and I have discussed before, in relation to Nigeria and Shell, at least at the African Commission, not at the court. And then lastly, of course, NGOs, but also experts can always join cases as amicus. NGOs can also bring cases directly on behalf of communities. You don't have to be an injured party in the way that you would in, for example, the European system. So there are a lot of ways in which individuals, NGOs can mobilize either at state level or go directly to the court and or go through the commission, which is something that isn't done very often. And that route has only been used, I think, 3, maybe 4 times in the last 10 years. So there are a lot of opportunities, but you have to know the ins and outs. And the court is not very good at self-promotion. I hope they improve, but this makes it harder for people to understand what's out there.
Yeah, precisely that. Thank you so much, Misha. Obios, if I could come to you now, let me say a little bit about Obios's amazing profile, because she's a PhD candidate at the University of Humanistic Studies in Utrecht. But the important thing to say here is that she's originally a historian. So what I really hope that we will have is a kind of a humanistic or humanities inflected perspective or insight into how we might think about conceptualizing climate justice. So having studied as a historian first, Obioso is now doing further studies in transitional justice at the university, or has done further studies at the University of Cape Town, and is now completing her PhD. And she's worked on a range of different topics relating to conflict and violence, and particularly to issues of non-violent conflict resolution in a wide range of fora domains, so not just academic, but also more broadly in places like schools, which I think is very important for this discussion we wish to have about generational conversations or intergenerational responsibilities, and our sense of a generation of having responsibility towards those who come after us, how we think about our role as good ancestors now. Before all of this, Obioso was a journalist in the Niger Delta, and I suspect that a lot of that experience was really formative in the perspectives that you bring to your work now, and we'd love to hear more about that if I can give you the floor.
Thank you very much. Yes, so I am a PhD candidate who's done a lot of other things before starting on this research. But my research focuses on transnational lawsuits against oil multinationals, and specifically lawsuits that are filed against Shell in the Netherlands. And when I was invited to speak for this town hall session, I was looking at the questions and I was thinking, okay, so what is it? What is it? Yeah, what are things that actually come up from my research that have to do with this issue? And I do have to say that I, for one, was really happy with the brackets in the climate justice, because the litigations that I look at are actually not climate litigations. Yeah, particularly two lawsuits that I look at. One is a pollution case, and another is a human rights case. But I still think that there are some very interesting, well, I think interesting observations that I can bring to this forum. So the big question that I want to really share with you, that I have in the course of my research, is why is it so important for the oil company, in this case Shell, to not be seen facing off against the victims? Why is it so important not to come face to face with victims? Just to tell you a little bit more about my research, and especially the two lawsuits that I look at. There are some similarities between these two lawsuits. Both of them are brought by Nigerians against Shell, filed in a Dutch court, in a district court in The Hague. And even though they focus on very specific violations of oil pollution resulting from leaking pipelines, but also the alleged complicity of Shell in the execution of environmental activists in the 1990s, when Nigeria was still a military dictatorship. But yeah, so these are very specific violations, but they represent and they really stand for very big structural violences and wrongdoings. Some of the differences I would say between these lawsuits is that one of them looks at violations that occurred in the past. I said this happened in the 1990s, these executions. The widows, 4 of those widows are actually the people who who took Shell to court looking for justice. And in the other case, it's much more about ongoing environmental violations, and also trying to change something for the future. So changing the way Shell behaves, making sure that these kinds of huge oil spills don't occur again. Both of these cases are now completed, not so long ago. And I guess a very important difference between the two is that one case was won, which was the case brought by 4 farmers and Milieudefensie, that was a co-plaintiff in the case, and the other one was lost. And the widows who filed their case against Shell decided also not to appeal their case. And I think it's really important when looking at litigations like this to realize that when you say they're completed, perhaps the lawsuit is finished, but the actual case, the story is not. They have an afterlife just as much as they have a before life. And I think for the sense of justice and feeling recognized, feeling that there's something is changing, considering both before life and afterlife of these cases is very, very essential. So what did change? For me, well, because my research is really about looking at justice in a very relational way, you can ask these questions at 2 levels, at the macro level and at the micro level. So when I asked different people who were stakeholders, who were involved in these litigations, when I asked what is important for you, how do you see justice, or how do you think justice would feel? I got very different answers depending on the kind of stakeholder. For example, people who were working for NGOs that also supported these lawsuits. I guess, as you would expect, they talked about the big changes that they wanted. They wanted to see as the relationship between the parent company of Shell and this local subsidiary of Shell to make it short, to end this kind of a distinction, not for the company no longer to be able to hide between this idea of distance between what is far away and what is nearby. But for plaintiffs, the victims, some of them would tell me that they really wanted to have, they wanted to come face to face with Shell. They wanted to be seen. They talked about a feeling of a weight being lifted from their shoulders, and being able to face each other as equals in the courtroom. And then one of the plaintiffs, actually one of the farmers, told me a story about the crocodile, which has a very important role in their community in the Niger Delta, because the crocodile is really the embodiment of their ancestors. And he thought it would be really, it would have been really important if representatives from Shell would have somehow participated in reintroduction of these crocodiles, which had gone nearly extinct in the Niger Delta, because this for him meant that there was a recognition of the value of this animal, but also the dignity of their ancestors. So why did I have this question about why is it so important for Shell not to come face to face with victims, with plaintiffs? And basically it is because from different people that I spoke with, they told me about how much trouble Shell representatives really went through to avoid, even in the courtroom, to have to look at plaintiffs in the eye, to greet them, to acknowledge them. And this, at a very micro level, this actually led to some very painful and puzzling moments, which to me just raised this question: why is it so important not to be seen face to face, looking the other person in the eye? So I think that distance somehow has something to do with justice, and it has something to do with the injustice. And I think, you can, I guess, conceptualize this in a number of ways. One of them is the way in which the technical aspects of this injustice, or the way pollution and but even climate change, the way that it can become a technical problem that requires just a technical fix, really creates a distance between the human part of this of these violations, and recognizing the humans that are involved in it. Another form of this distance and the injustice of distance, I would say, is this parent and subsidiary construct. And of course, transnational litigation, these types of litigations also very particularly try to undo that, the fruit of that construct. Access to remedy for victims of corporate harms has been very difficult, and these litigations really try to make it, to create access to remedy, even though there's still many hurdles to overcome. And finally, I want to say something very briefly about about tropes of victims and villains and heroes, even saviors, that can sometimes be that can come out of these processes, litigation processes, and they're not always very useful, and they can even contribute to reinforcing the distance that is that feeds into the injustice. So I will just leave it with that, and I hope that that I contributed to sparking lots of discussion. Thank you.
My microphone. Your comments, for me, supplement the conversation that we started to have there about the kind of temporality of thinking about not just climate justice, but justice. Thinking about historicizing our understanding of what climate justice and justice overall might look like. You supplement that understanding of the temporality with a reminder that we also need to be thinking spatially. So this question of distance, I think, is so thought-provoking. So the idea that that wrongdoers want to create or want to maintain epistemic distance from those who've been harmed, and do go out of their way almost to create that distance, seems to me really important. And I suppose the question for me then is, to what extent the legal fora facilitate that. The whole setup of the domain in which you have to work is precisely to maintain the distance between the wronged and the wrongdoer, and I think it's almost as if it's designed. It's not just a kind of it's not just a it's kind of built in. It's a failure of the system that's built in, because not to maintain that distance would be to actually have to listen to what the claims are. The claims are, the way that you describe them, are restitutionary. This idea that we want you to reintroduce the crocodile as a way of acknowledging the kind of past wrong is a way of saying we want restitution, right? We want you to return us to this position that acknowledges the important role of this kind of spirituality of this space, not just its functional, part in our lives.
Yes, so I think you're right, and I also think that beyond restitution, it's also about entering a process together. So actually taking responsibility to jointly think about what should be done. I think at least for this interlocutor, it was something that was very important, and that the legal forum did not provide any space to even think about that. But I do have to emphasize that he was also really happy about all the things that the legal forum did offer, and was quite realistic about the limitations. And I just want to also emphasize that at least everybody that I spoke with was fully aware of the going to court was a last resort. So it wasn't like they were looking for the ideal forum and chose to go to court. They actually tried a lot of other things that they would have preferred, like just entering into a one-on-one dispute resolution or dialogue, whatever, and finding compromise and seeing where you could. So actually, I have to say this was the pollution case, where there could be a compromise found. But of course, the problem was that there was no response whatsoever from Shell. So this was where they ended up.
It's almost, looking for an afterlife. Sorry. Oh, yeah. Yes, you might want to read that. So that's just directly from Zelda. So just to finish on that point, it's really, the wronged looking for what might have been an alternative afterlife to the case, an alternative way of looking for justice that's kind of denied because the legal forum becomes the only resort that they have. These are really important perspectives, I think. I think Zelda is not able to join us because of limited access. Is that right, Margareta? Yeah.
She has a message here.
Brilliant.
That I can...
Would you like to read it?
Yeah, so what Zelda shares with us is that she has limited Wi-Fi access right now. I'll quote from now, but I did hear most parts. It's a bit late in the Philippines and I'm using my home phone signal. If you can read and share my chat, it would be great. Margareta has shared very well the gist of the climate justice case in the Philippines. What I can say, like an update, is that many of the petitioners of that climate justice case are currently complainants in a consumer complaint against plastic, which is another form of fossil fuel. And according to studies, fossil fuel corporations are investing more and more in plastics that aggravate the climate problem. Thus, the fight against plastic is deemed a dovetail of the climate justice case that we, including Margareta, worked on a few years back. So that's, I think, a very important reminder from Zelda that many of these justice struggles are intertwined. And well, those of us who are working on this question in particular would like to connect. I think it would be very good to reach out to Zelda and continue the conversation and see where we can create and exploit synergies.
Thank you. That's really helpful to have those additional comments. I do hope in the future perhaps we can make sure that we can hear from Zelda, and I think it's really interesting to make those broader connections about how corporations are able to move so seamlessly into new areas like that, kind of as a response, and how nimble they can be. And it's just to me that we also need to be really nimble in our thinking to try and kind of almost foresee what the next moves are going to be. Do I have an opportunity, if I may, Jeff, to open, Rana, to open to the floor? I have 5 minutes left. It's not so easy to see all of you, but if there are questions, it would be excellent to be able to hear from you, to hear any questions that colleagues might have, or thoughts that have been provoked for you, questions that you would like to ask of our panelists, or areas that you would like to urge us to go into in the next session. Yeah.
I just want to last point about participation. About getting talk about it. What do you need is that by that thought about how should we talk about the stages? We need to correct them at one point, but then we should use.
Did you catch that up, yes? Yeah.
Well, okay, yeah, thank you for your question. So what I was referring to really is that these lawsuits have a narrative that's well, yeah, apart from the narrative that people have from themselves, from their own life experience, and the legal narrative that actually needs to fit into a claim and needs to find a fit to be recognized. But there's also often a public campaign and a public public narrative that is created to gather support and to really make it for the broader public, really, to make them understand and to make them feel empathy for the people involved. So in the case of the 4 widows who sued Shell, you can see that there's a very strong narrative of David versus Goliath, like the small person against a very, very strong, powerful opponent. But also often there's a tendency to look at the people who are plaintiffs, who've been affected by violations, to really to paint them as victims, and instead of also showing that often these people are activists and people who take their destiny into their own hands and who make very strategic decisions to change something in their own environment and change something not just for their immediate community, but also in the bigger picture. So what I'm trying to say is that on the one hand, there's a tendency to make the reality much more simple, so that more people can understand it and also support it, while the reality is often much more complex, and communities are not monoliths, of course. There are people who gain more, and there are people who gain less, even when a case is won, depending on how it's framed. And so this is what I was trying to refer to.
Thank you. Are there any other questions?
Ma'am, you mentioned India and Pakistan, climate impact. We all know the devastations recently. Whatever has happened, most of the countries which are affected by climate they are being ruled, or they have been ruled by the most corrupt ruling elites. So the funds which are given to those countries, to those regimes by UN and other donors, do we have any accountability on that? Do we have any proposal that this money is used properly for those who are affected? Let's say Pakistan, people since 6 months, they are still living under the open skies without a shelter and in a horrible situations. Thank you.
Misha, do you have any kind of examples of precisely this kind of, I suppose this is the afterlife question again, isn't it? Margareta, you might also, on this question of what happens after we've mobilized, we've drawn attention to, for example, the floods and we've achieved the kind of we've drawn the public's attention to it, but we take our eye off this subsequent stage, if you like, which is what happens to the funding, the support that goes in. How do we ensure it goes to the right people? Are there things, maybe Margaret, you want to answer this, that you've picked up on following some of the litigation that you've seen in some of those good examples in the Pakistani and Indian examples?
I guess this is then a very legal answer, but in the Lagari case that was brought before the courts in Pakistan, ultimately ended up before the Supreme Court. The Supreme Court of Pakistan assumed what is called continuing mandamus jurisdiction, and so ordered the government to implement the its own climate policy, and to set up a climate change commission, and really saw to it that this was set up and that it started to adopt policies and it started to function. Now, to what extent that then really brought about positive change on the ground, that hasn't been really studied, and I am not able to really verify what it did. But from a legal perspective, it is positive that a court is willing to go a step further than just issuing a judgment and leaving it at that, which happened in the agenda case, for example, where there's also an implementation problem here in the Netherlands, because our courts do not have that ability, or do not assume that kind of mandate to oversee the implementation of a judgment. So that is a tiny little bit of an answer. And of course, there is much more to say about accountability of governments for implementation of policy, disbursement of funds, etc. And it's very, very complex. I don't think we have time to really unpack it.
Yeah, maybe to add to, I think that there's different issues at play, right? So on the one hand, we have the question of the what the courts do, what the courts say, and then you have what the states do. And what I see, at least in the context of the African court, is that sometimes there are decisions rendered and they make very specific demands on the state. And you can draw an analogy between that and receiving funding, for example, to resolve a particular problem from the UN or whoever else might be sending money their way. And what tends to happen is a couple of things. On the one hand, states, I think at least someone who works on human rights is always this assumption like, oh, the state doesn't want to comply. They're not going to listen, but actually they quite often do. But then there comes issues like, for example, sometimes courts demand that certain things happen and the legal changes take place, but the state at that point in time is not ready or not able to do it for a whole bunch of different reasons. And there are a lot of domestic processes that need to be undertaken. And it's the same with dispersing funds, right? You receive the money, but the actual practical disbursement of those funds or goods, the logistics of it can be so complex that even when funding comes in, or even when a good decision is rendered, the actual practicality of doing something with that is not so obvious. And the amount of time that it takes is incredibly frustrating for everyone involved, including the afterlife of cases. So I think the point made is very valid, right? That we might have good decisions or we might have help, but it doesn't actually always lead to change, or at least not the kind of change we want to see within the time frame we want to see it, especially in circumstances as desperate as these kinds of climate disasters.
And one thing is just really important to add here, which is that the biggest problem, at least one huge problem in this context, is also the lack of support. So surely there is humanitarian aid being provided to Pakistan to deal with the floods, but there is no, not yet a fund to pay countries that suffer climate harm compensation, right? That is a big, from a global perspective, it's not the polluters who are paying, it is still mainly the victims who pay, and then they get a little bit of charitable assistance is thrown at them. So those of you who follow the climate negotiations will have noted that now there is an agreement to set up a fund, but it's really an empty bucket. There's no a single penny in it. And so that needs to be said as well. It's not a question of, oh, the governments in the global south are corrupt, and it's not because that's a very cynical discourse that you hear sometimes here, especially on the right side of the political spectrum. I think we have to be a bit cautious also in not kind of, inadvertently yeah, exactly.
That and if you don't have the fund, then you don't cause the kind of structures that are needed to disperse them to be set up. You just kind of push the money out, and it simply can't be absorbed because the structures aren't there. That's part of the harm of the reluctance to set up the fund in a long-term way. That's part of the harm that will cause. Absolutely. I think we have come to the end of this session. It was hugely thought-provoking for me. Thank you to those of you who've asked questions. I hope you'll join us for a break, and we'll be back for a second session where I hope we pull through some of the threads of this early conversation to talk about for whom are we mobilizing and with whom are we mobilizing. Thank you, all three of you, for beautiful comments that I think have been really important to set the ground, because this is what we're doing today, is to start to set the ground for the sorts of conversations we want to be able to have together. Thank you all. We're going to start our second session this afternoon to discuss, picking up on some of the themes of earlier, the question of what we're mobilizing for and with whom. So the questions that we've been asked to address here are, how does the mobilization get led? Who makes decisions about the form that mobilization might take? What are the institutions, the sorts of structures that we will have to navigate? And we talked a little bit about that earlier. And I hope we'll build on those conversations now. And then how are we building alliances? How are we working with comrades? How are we building, involving communities and working with particularly social movements? And we couldn't have a panel better qualified to address some of those questions than the one that I'm now going to introduce. So to begin with, we're going to hear from Waruguru Gaitho, who is a PhD candidate at Cambridge. Gaitho is a human rights lawyer and academic whose work focuses on law, gender, and sexuality. She's an advocate of the High Court of Kenya, earned her LLM from Leiden, and has since been working in what could not be a more important area of work at present on LGBTQIA plus issues in Kenya, on legal and social advocacy. And as a Kenyan myself, I can tell you that there's no more painful or urgent time to be
working on these issues. Gaito is currently working in her doctoral research on how bisexual and queer women mobilize to protect their rights, using Kenya and South Africa as her two, if you like, illustrative examples or case studies. You're very welcome, Gaito. If I may just ask you to make some comments. The format that we're going to follow is that you'll make some comments and then the others will follow, and I'll try to draw out some of the kind of common themes between us. You're very welcome.
Hi, hello everyone. I hope you can hear me. Yeah, okay, good. Well, this set of questions was really interesting for me because it directly led me to think about my own work and my own project, because these are central questions to the way that I am structuring my research, and also potentially questions that I myself will be asking my research participants. I think one of the things that always strikes me, and this is drawing from my experience in the field as an actual practitioner doing this work, has always been how and why we center law as the starting point of our advocacy. I think one of the things that we have to contend with in answering these questions is that we often will have to look beyond law. The communities that we engage with and that we are looking to work with, and I think this has already been mentioned by Misha as well in the earlier panel, do not necessarily start from a point of law, nor do they look to end with law. And so I think one of the things that we have to deal with is in accepting that we have to be ready for non-legal solutions we brought to the table, and we have to sort of be ready to deprioritize law, almost ironically, in the moments that is important. Drawing specifically from the fight for queer rights in various contexts in Africa, the political weight of the notion of queer rights is something that we ought to focus on, potentially even with greater emphasis than legal mobilization sometimes, or than strategic litigation specifically, not the entire work of legal mobilization. And I think sometimes that's not something that people who walk into the room with a legal mind are prepared for. And so that's one of the things that I was looking at the questions and thinking, well, do we make space for building non-legal solutions around the legal work? Do we make space for being open to reprioritizing the role that law plays in this social transformation and political transformation that we're trying to do? And so that's sort of like an additional question that I have in this session. I think the other thing that's also really important to me is, in a practical sense, as we do this legal mobilization work, do we make space for figuring it out as we go along? I mean, we talk a lot about efficacy and we talk a lot about, you know, trying to get certain results, but legal mobilization, I think, as a fully collaborative project, is something that is really organic and does not take shape for, or does not fully take shape for a really long time once you start to do it. And so it's more a process of trial and error, and it's more a process of asking these questions or finding different ways to ask those questions, or asking you know, different people these questions, and then coming up with, in an iterative sort of way, coming up with solutions that get us to a better place, but not necessarily the perfect endpoint that we're looking to. So these questions to me are prompts rather than answers. They're prompts to fine-tune other questions, and they are prompts to keep in mind that if our end goal, which for me in my work is something that I would like to think I'm focused on, is liberation and is transformation of contexts from being oppressive to being emancipatory. If this is the end point, then that becomes the underlying basis of all the work, and law is only as useful as it is employed to get to that end. And if it is not the thing that is most important in any one context, then something else becomes as useful. So in this case, that might be political engagement before you go to court. It might be speaking to judges for several years before you feel confident to table a constitutional petition on, the rights of sexual minorities. It might mean working with certain political leaders to have them start to put this on their agenda. It might mean engaging with the public on Twitter before you bring a case to court, right? Which sometimes you don't think about if you're coming from a traditional legal perspective, or might not seem very effective if you are looking to strategic litigation as the thing that delivers you the greatest results. So yeah, that's some of my thoughts on these questions.
Thank you so much. I mean, your comments provoke a kind of question for me about, again, kind of historicizing contemporary struggles for queer rights in Kenya, and how they might draw on, I suppose, other analyses and other domains. So I'm thinking here about, a theorist like Isa Shivji would say, we know from the experience of working class struggles that law functions precisely to dampen down demands. That should make us very suspicious about using law. That's a very difficult thing for us Kenyans to hear, because we have a new constitution, we want to use it, and we're reasonably romantic about it. And actually, Isa Shivji's been a very powerful voice for, hold on a minute and think about what are the limits of prioritizing or giving weight to the law in this way. So I suppose my question for you then would be, to what extent has law actually served to, or our sense that we can resort to law serve to dampen down some of those queer claims that we would wish to make? And what would it look like if we just decided, right, law isn't a feature of this at all? We're going to just knock it off its pedestal. We're going to put our legal training to one side, and we're going to think about how else we might bring about change.
Yeah, those are very, very good questions, Sabrina, and I'm not really sure that there are ever answers to such questions. I think that in the first part, thinking about the Kenyan context specifically, at the moment, we're seeing sort of like this reckoning of the limits of the law with regard to dealing with a society's attitudes toward homosexuals. And for those who are not aware, there have been a series of incidences of violence and murder against queer folks in Kenya, which is absolutely harrowing. But there has also been, alongside the publicizing of these incidences, there's been conversations around law and the limits of law. There have been conversations around to what extent do we trust a justice system to investigate a murder of a queer person? To what extent do we think that is occasioning even more violence on the queer community? To what extent do we allow the court system to take over? To what extent should we be taking to the streets instead? And overall, there is a sense of, I think a lot of people are definitely very jaded and disillusioned with the notion of the legal system as being, efficacious. But at the same time, I think about, a former Chief Justice, Willy Mutunga, who in his address around, the promulgation of the new Constitution of Kenya was very clear and categorical about its decolonial possibilities. And he referred to the Kenyan Constitution as a second independence. And that to me is, and he said this many years ago, nearly 10 years ago at this point. And to me, that's really useful because in thinking also about your comment on historicization, I am drawn to the fact that Willy Mutunga was not in that moment specifically addressing queer rights specifically, but he was building the initial platform on which future work could maybe stand. And he was also potentially giving an avenue to other people, not necessarily lawyers, thinking about this liberatory work. He was giving an avenue for looking at the law as a transformative tool in and of itself, but also looking outside of the law and looking to history and looking to the aims of the Kenyan people, like things that we can also still draw from to do really useful decolonizing work. So in my opinion, I think that the law still continues to hold a lot of weight, but we also can't deny that a people's will is shaped by more than just law, and we have to understand and reckon with its limits. And so I think the effort has to be consistently being very humble about the limits of the law, and at the same moment still trying to push forward using this instrument and this tool that, yes, has been used in a way that's really oppressive and actually represents, is an institution of oppression in its own right, but in its own, ways also an emancipatory tool. But yeah, it continues to be a question that whirls around in my and all of our heads as we think through these questions and through the complexities.
Thank you so much, and thank you for the reminder of allies as well, because it's difficult at the moment to remember that in the face of it's a really dark time, in the sense that we have faced, all of the recent events in Kenya have reminded us, if we needed reminding, of the depth of the homophobia that we're faced with. And actually just to be reminded of allies making the ground for us even before we knew the ground was being made for us is really helpful. I remember Willie Mutunga saying at the 10th anniversary commemorations of the Constitution, and it was so interesting to hear a former Chief Justice say this. He said, the cutting edge of the liberation struggle in Kenya now is artists. And I remember being really taken aback and thinking, no, he's absolutely right. He's absolutely right. And it was because in the interval of the commemoration events, we had artists singing and playing music for us, just in the same way, actually, as Rana has set us up with music in this venue today. It's a reminder that, our convention is, you do your academic work and then your entertainment, music, etc. is for afterwards. That's clearly not true, that clearly these different domains colliding, coming together are what's most powerful. Thank you so much. We'll come, I'm sure we'll pull threads through and come back to what couldn't be a more urgent conversation right now. Thank you. If we come next to Eva, Eva, just to introduce you.
Could we read some questions from the online participants that connect directly to Gaito's comments?
Are these comments for now? Yeah.
We can just read some of them now, and then we can reflect on them as the conversation goes on.
That would be great.
Yeah.
Yeah. Do you want me to read them out, or do you want to read them out right now?
I'm happy to read them out.
Yeah,
because I also have them in front of me. So from Busari Jamaldeen, the voice of the masses is a sensitive attribute of democracy. However, laws are static and it fails to attend to some human societal quests. How effective can laws be extended to cover the required needs of human societal needs at a particular point of time wherein the law is silent on that particular matter? That's the first one. From Jacqueline Dugard, who's also a member of our advisory board. It's interesting that the critique of law demobilizing struggle is often made, but hardly ever analyzed empirically. My investigation of empirical studies of legal mobilization only serves to confirm the power of legal mobilization as part of struggle. In other words, law as empowering, mobilizing struggle. And one more from Abdul Latif Ibrahim. Insightful so far. No doubt legal mobilization is a viable measure to use the legal system to push for social reform. In Nigeria, we've had protests against police brutality yield no fruit. How do we utilize legal mobilization in this regard? And who can bring such claims in the first place? So questions to reflect on as we move on. We can go ahead.
Thank you for us to reflect on as we move through the rest of the day. They're really great comments and questions from the online colleagues that have joined us. Thank you. To move now to Eva. Eva Rita is a senior lecturer, senior researcher and lecturer specializing in public international law and human rights law. She took her PhD with a study on provisional measures in international human rights adjudication. Her expertise is in the area of substantive remedies, comparative regional human rights systems, and follow-ups to international judicial decisions. Actually, some of the kind of topics that we were starting to discuss earlier. Substantively, her focus is on the rights of detainees, has been on the rights of detainees, human rights defenders, indigenous people. And really interestingly, Eva initiated and coordinates work on clinical legal education, from which I think we can learn an awful lot actually in relation to legal mobilization. If anything, that is really the cutting edge of legal mobilization work. Again, generationally, the huge energy of our students I think has an awful lot to teach us about quite what legal mobilization means. And to some extent, it means rolling up your sleeves and working, simply rolling up your sleeves. And students, there's no better example of that than the work that our students do in their law clinics. So Eva, over to you.
Thank you. Well, it's great to be here, and thanks Rana and the steering group for the organization. I'm really tempted. I mean, also what you say about and what was said before about the intergenerational and the different generations, and indeed the current students. To get on that already, but I'll stick first to my the 4 minutes that I timed. I'm happy that this platform functions in a hybrid way that allows members to meet and connect also online. So nice to meet you this way. Organizers, I think, raised important questions, and just now some more very interesting and important questions were added. I will discuss some of the questions raised from the perspective of a law clinic. And the law clinic in Nijmegen wants to contribute to legal mobilization and to assist master students and staff on their ways towards academic citizenship, or to look back at the previous panel, maybe, or becoming better ancestors. It is learning as a group by doing academic research, responding to questions by civil society organizations. So we are not a clinic that litigates itself. And this is just our 2nd year, and we are very keen on your input and perspectives. One question that the organizers raised is, who are we mobilizing for? Right now, the law clinic focuses on human rights, and it works with organizations mobilizing the law for groups claiming their rights having been structurally violated. And another question you raised is, who are we mobilizing with? So the clinic mobilizes with organizations, and the organizations are part of a movement for change. And we think these organizations should mobilize with activists, representatives from the groups claiming structural violations. And that means a constant dialogue with activists, spokespersons who have knowledge from their own experiences, communities, heritages. And what is it that they find important? I think Obioso already said this in the previous panel, the legal stories need to reflect the community stories. And the clinic only joins indirectly in this mobilization movement through an organization. For the clinic, this means at least 3 things. 1, the academics involved need to constantly reflect on the role of the clinic and how the commissioning organizations work. And 2, we need a diverse group of master students that can really bring different perspectives. And 3, each year the students need to reflect together on their roles and also what they can teach the older generations. The organizers also raised the question, who leads the mobilization? And I think, again, those are the community representatives. And there's the question, who makes the decisions? And this, I think, depends on the kinds of decisions. And that depends also on roles. In a strategic litigation organization, I think the lawyers of that organization should make the decision whether or not to take on a case and whether or not certain legal arguments and choice of fora are wise. That is based on their professional roles. But the community representatives need to agree with the eventual decision to litigate. And this means a continuing dialogue. And you cannot have legal mobilization without this and without the initiative and the informed consent of the peoples whose rights are claimed. And I think a major challenge here is for the lawyers to stay aware of the various groups and interests within a movement. And that is something I think we also need to try in the clinic, as well as looking at the perspective, at sort of all the other disciplines that are relevant and the other measures that are not necessarily legal. In the clinic, there are also different decision makers. A project is academically assessed at the end of the clinic course, and until then, I think it should be the group of students that decides on the research. afterwards, the academic supervisor and the coordinator decide on how to submit it to the organization. And that is based on the responsibility for the clinic and for the university. And that brings me to a last question that was raised by the organizers. What institutional structures and systems do we navigate? I guess we must all navigate and tackle bureaucracy and ingrained biases in ourselves and others. The law clinic must also navigate practical stuff like the relevant master schedules and the exam board and the interest of maintaining a high academic reputation. But navigating institutional structures also means, I think, engaging with scholars who are used to traditional teaching and who fear that the clinic is political and activist. We need to reflect on these things all the time, and that makes me so happy that we are launching this platform. Here we can connect and between persons with different perspectives and between organizations and academics and clinics and learn from each other. Thank you.
Break. Okay. Okay. Eva, I think you've finished your presentation, but I did have a question that your presentation provoked for me, is a question about what the potential is for law clinics to enable students to reflect on their legal education more broadly, because we can teach, I suppose, theorize legal mobilization at an abstract level, but there's nothing quite like actually giving our students the opportunity to do clinic work. But I've often wondered about how much transformative potential there is in that clinic work, in the sense that I think it for some students, it's almost the first time that they've confronted these really difficult questions about the limits of law and about strategic choices and about the voices of communities, and are quite taken aback, when communities, again, going back to our discussion earlier, communities are very strategic and very careful about, when is the right moment to use law as an instrument and when might it be best to hold back, and very clear about what it is that they're aiming for. And students, I think, can't possibly experience that from books. That the only way they can ever really feel that is really to feel it, actually, to feel it in the conversation with communities with whom they're working in clinic. But I'd just be really interested in your reflections on what that does to their other, their perspective more broadly on their legal education, because I think there is a huge potential there to think about clinic as having this wider impact on how they think about themselves as kind of recipients of legal knowledge and as legal actors.
Yeah, that is in. I mean, I think the crux of it, because I have the impression even that that partly we and the students have to unlearn certain things that I learned before in law, in the bachelor and in other master courses. Maybe in a way that they would otherwise do next when they start working. But I also noticed that we, as with three now teaching the law clinic, we are more ambitious, and we can actually, we cannot squeeze everything in that one period. The nice thing is that you can also take some of the students stay on the project after the formal end of the clinic. And they can also join in for instance, with the project, the public interest litigation project, we discussed with some of the students, also subsequently with some of the activists about the project. And I think it also depends a bit because there are many different types of law clinics. And I think with some law clinics that are very established, in the US, students are also trained to do interviews, maybe even with local groups, etc. And then they really learn a lot, I think. But what we try to do is at least have a good mixed group of students and have discussions and reflections and asking for personal individual reflections on their learning process within the smaller research group. And we visit organizations. Yeah, but that's more the practical stuff. In general, I think for students, it's a great opportunity to step back and really reflect and really look at, okay, what can you achieve with the law, and what can you achieve when you are just graduated from law school, etc. And indeed relative look at what are our own motivations, and yeah, how do you say, well, not this sort of this traditional savior reflex, but more the okay, what is it that an organization they know what is needed, especially the communities, and what is it that we can, what little thing can we do in terms of research for that.
Thank you very much indeed, Eva. I think there's a huge amount still to learn about, reflect on clinic, and I think that the literature still is nascent about the role that the clinic plays in legal mobilization and legal education more broadly. Coming now to Jeff Handmaker. Jeff hardly needs an introduction. He's been the driver together with Rana of the Legal Mobilization Platform, and any of you who know Jeff both as a socio-legal scholar but also as a colleague will know that he's somebody who is utterly dedicated to making opportunities for others, whether that be his colleagues, his students. I've seen it at firsthand through many years. Jeff has a long association, and I think this is probably how we came to know each other, with Southern Africa. And he is, and this is notable for me, he's an editor of the Southern African Journal of Human Rights, which is really setting the pace for the rest of us. We're all barely trying to keep up with the journal and its excellent work. So Jeff, over to you for your comments.
Well, thank you very much, Ambrina, for the very generous introduction, and thank you to my colleagues for your presentations. I also, of course, want to add that Margaretta's role in the steering group, which has really helped sort of bring us all together in a process that goes back about 5 years. We've explained this in a special issue in the Journal of Human Rights Practice, which is really interesting in terms of the whole journey of getting here. It's been quite a journey, and I think these questions really speak to the challenges of how it is we now take this journey forward. So who we are mobilizing with, who we're mobilizing for, to me, it draws on my experience both as a human rights lawyer in a previous previous career, and as a scholarist, both for the past 16 years or so. And this is basically recognizing one's privilege, one's gendered privilege, social and economic privilege, and certainly white privilege. So critical scholars problematize this, as we know, recognizing the positionality one has in relation to the issues that people that are the focus of the research face. But more crucially, social justice activists often insist upon this, asking who and in what manner individuals can credibly speak out on issues such as, which is very much an issue in the Netherlands at the moment, the Dutch slavery and colonial heritage is also an issue which we are focusing attention on in the platform, with working particularly with organizations like Systemic Justice and the Black Jacobins. So organizations like Systemic Justice characterize this as community-driven litigation. I think that's a really nice way of capturing for whom we are mobilizing. Who leads it, I think is really, and it's been said already, is certainly led by individuals and organizations who experience the violations. So what is one's role is, I think, a question that needs to be asked very crucially. We're a large and broad platform of research and practitioners, and I think we have a shared interest in better understanding and reflecting upon what forms of legal mobilization work and what don't to trigger transformative change. But these roles are very different. What researchers aim for are solid arguments. For practitioners, it's a change itself. And for both researchers and practitioners, it may involve standing up for, but also stepping back, allowing others to take up the research or advocacy space, supporting others, what our colleague, Dr. Aminata Cairo, refers to as holding space. The question that Rana posed to us on what institutional structures and systems we have to navigate, well, there are myriad institutional structures and systems that pose great challenges for legal mobilization practitioners to navigate, and of course, researchers to engage with. And this relates to what I said earlier. First of all, it's a patriarchal character of law, legal process and systems, including universities and the legal profession, how they're organized, that structurally privilege men, but also the manner in which these institutions operate, non-collaborative, individualist, highly competitive. It also applies very much to social justice practice, unfortunately. Another aspect is that the racialized character of law and legal process and systems that in similar ways structurally privilege white people, the elitist tendency of law, legal process that systemically protects interests of extremely wealthy people, such as owners of social media platforms like Twitter, which is all of the above in terms of the problems I've been referring to here, to avoid equitable distribution of wealth. And then finally, the tendency of law and legal process and systems that structurally privilege humans to disregard non-human interests. Here we're talking about the rights of nature, which researchers such as my ISS colleague who is here today, Dr. Dafina Misijan, focuses much of her research on. All of this involves a great deal of legal learning, which another one of our colleagues, Karim Kneel, refers to as understanding how law is used to manage crises. And I think that this is really becoming an important entry point to what we're trying to do on the platform. So finally, how are we involving communities and movements? Well, first of all, I think it's quite clear that it's much more than litigation. Indeed, as Gaito has said, it's much more than the law itself. Legal mobilization is about using many different types of law, using law in very many different ways, and indeed looking beyond the law and what's missing within the law. As Eva Rita and I have argued earlier last year, this can also adopt cooperative forms, participation in policymaking processes, training courses on systemic racism awareness, partnerships with municipal and national government actors, and law enforcement officials. This is also a point I think that Misha was making earlier on. But there are indeed also protests, confrontational forms, protests, corporate shaming, civic boycotts, and these also need to be taken into account. So whether we're using law as a shield to protect or as a sword to actively advance social justice claims, as our colleague Richard Abel identified, or indeed as Greenpeace mentions, as armor, efforts to undermine legal mobilizers through lawfare need to be protected against, specifically through slap suits and the like. How to involve communities and movements in the work of legal mobilization is, for me, primarily about solidarity. And as I learned working in places like South Africa in the early 90s, and of course continued to go back and forth there, and also in Palestine nowadays, it involves first and foremost listening to those affected by racial, climate, and socioeconomic injustice, which in my experience as an academic and as a practitioner is not always easy for people. It often involves, and particularly in the way the legal profession is organized, which is, lawyers decide the direction of litigation in particular. It's not always, so it's not easy. It often involves a fundamental questioning of liberal values, as the public interest litigation project, which is also represented here today, asks, where does it hurt? That is their starting point for even beginning to become involved in something and in dialogue with partners they're going to be working with. So I want to kind of conclude with another reference, which I found extremely inspirational. And that's the Zwarte Manifest in Dutch, which in English is translated as the Black Manifesto. And it begins, as a lot of these manifestos do, with Article 1 of the Constitution, of the Dutch Constitution, that states everyone in the Netherlands is treated equally in equal circumstances. That's the liberal premise of the Constitution. But these are words, as they say, that must guarantee every Dutch person to have an equal existence. But the reality is different. In the Netherlands, there's a racialized order. It is unacceptable, and that inequality and injustice based on race are the order of the day in the society is also unacceptable. So the manifesto, and I really encourage those particularly who speak Dutch, however, understand that they're working on an English and other language translations. It delves into 12 key issues that particularly affect people of color in the Netherlands, including issues core to the work of the Legal Mobilization Platform, namely education, healthcare, and housing, the job market, and economic equality. It also makes clear that, and very much inspired by the work of Gloria Wekker, that these issues can only, who's a member of our advisory board as well, that these issues can only be addressed through an intersectional approach. In other words, the claim of the manifesto is not for equality, but to redress inequalities. Or again, what Becker refers to as radical equality. So that was my answer to these questions. And yeah, thank you.
Thank you, Jeff. I suppose for me, the question is, you know, where do we put the brackets? So to what extent we want to hold on to the idea of legal mobilization in particular, because clearly nothing in our training and our self-understanding as lawyers prepares us for the idea that our role is to critique power. You know, on the contrary, where I think lawyers tend to accept and to reinforce existing power structures. So what's the scope for talking beyond our own disciplines to non-lawyers, to colleagues from, for example, the humanities, and what might that bring to us?
Well, that's an interesting question. And Karen, my colleague Karen Arts, who's also in the room, and I organized a conference some years back where we invited a very well-known critical legal scholar, Martti Koskiniemi, and he helped us address this through art, through an image of the duck rabbit, which has become kind of an image that we've used to present the work of the Legal Mobilization Platform. And the idea essentially is that we need to get away from this binary understanding of politics and law being totally separate universes, and that you shouldn't be doing politics if you're doing the law. Lawyers have no business being involved in the work of politics. Of course, that's quite nonsensical. It's totally much driven. Law is very much entrenching interests and power relations, and you have to have a very political understanding about how law is created in the first place, what has been framing the law in the first place, and of course how it's mobilized, because an even deeper engagement with the politics. So there certainly needs to, within legal education and the work of law clinics, as a really crucial, I totally agree with you, really crucial form of experiential learning, to ensure that there is much more sophisticated understanding about what are the politics at play and how to manage that. It's not about avoiding this discussion. I mean, if you hear the words of the prosecutor of the ICC, for example, I mean, she and now he was very much at pains to say what we are doing is non-political, it's legal. I mean, it's quite astonishing that still in 2023, we are speaking like that as senior lawyers. Of course, the reality is that it's profoundly political, and rather we should engage in the political nature of it. Not that it should be politicized, that's something else, but certainly politics are very core to everything that's happening there. We need to understand it better.
Thank you so much. I'm going to give an opportunity, because we have a little bit of time, because I know that there will be questions from the floor for our three speakers. So if there are questions that you have, provocations, things that you'd like clarification on, do just put your hand up and we'll get the phone up over to you.
You have to stand up, Itai, if you want to talk to the microphone.
Yeah, thank you so much for your contributions. It's been really inspiring. So sort of, I'm just was thinking of a lacuna maybe in the conversation, which is we're talking about a lot about practitioners and communities as if they're somewhat divorced, right? And obviously, sometimes that's not the case. Often that is the case. I was also thinking about this is a question, I think, what purpose for what to do about the lawyer or the practitioner who's not divorced from their community, but also what to do if a community is disorganized. Because a lot of structures in our societies, neoliberal societies, especially today, disorganize communities, especially when it comes to political power, right? Especially racial communities, especially gendered communities, especially also socioeconomic communities, right? We complain endlessly as Marxists maybe about the disappearance of the European working class, or European Marxists do. But anyway, so this is also a question, is what is the practitioner to do when a community is disorganized, if anything?
Reflections, would anybody like, Peter, would you like to make some comments?
Yeah, sure. The first thing that came to mind for me is if a community is disorganized, I think the logical answer would be to create spaces where the questions that might lead to organization could be asked, create spaces where folks can come together and reckon with the things that they are afflicted with, but also find connections and build solidarity. And I, as always, like draw from this work, which is also really funny because of your comment on what happens when a practitioner is not divorced from the community and also vice versa. And that I think is a continuing conundrum, at least in a personal sense. But I'm thinking about queer communities in Kenya and how they found ways to show up in spaces that maybe are not 100% safe, but to sit down and think about the ways in which they are linked by struggle, but also the ways in which their struggle is different across different contexts. We often think about, for example, queer rights struggles as being national, but we now know, or international or regional, especially if you're thinking as a lawyer, but we now know, for example, in the Kenyan context, that the life of a queer person in, you know, a town like Eldoret is very different from the life of a queer person in Nairobi. And to make assumptions about what one needs versus the other, or to make, you know, the assumption that you can lump these two groups together is inherently flawed. And so I think the first thing is to try and create spaces wherein those questions can be asked and wherein we can build solidarity, but also we can make admissions about the ways in which our lives are separate or distinct from each other. And what does that mean for the strategies that we then build out of that? Yeah.
Thank you very much. Are there any questions online, it occurs to me, Rana, that we might want to address as well?
Yeah, there are quite a few. I'll start with the first one from Azubike Onora Oguno. What are the strategies going forward to sustain interest of growing students in the Legal Mobilization Platform?
Eva, would be very interesting to hear your thoughts on this. Yeah, how to sustain, because it takes enormous energy and commitment actually on the part of students, and of course students graduate and so on. So how do you alluded a little bit to, you know, making sure that past students are put into contact with students who are coming up through the legal law clinic and making sure that they see themselves as part of this community. But it would be very interesting to hear your thoughts on this question.
Yeah, I think it's a very good question, and we are still also trying to find out. We are just starting, so how to go about that. And I also really agree that this is also as you go along, you find out what works and etc. Kind of thing. Well, one practical thing is that we did was making a private LinkedIn group for last year's group, but we need to sort of follow that up. And now we have a website, so so in that way, we are also connecting the students again. And of course, we are also stimulating follow-up actions. For instance, writing an article together, or when we are hoping that some students will prepare blogs, and I think those things. And we are having we are organizing online conversations between alumni, human rights alumni from this university or from Nijmegen, who are working in the human rights field with the current students. And I already, see that is being followed up. So those are small things that we try to do. But I would be very interested in other suggestions.
Thank you very much. I think we may be out of time. Am I right, Rano? Do we have time for another?
We have time for one or two more
That would be
questions.
great. Is there one in the audience?
This side of the room?
Fantastic.
Hi, thank you all for the interesting conversations, the ideas you proposed. And when I was thinking about what legal mobilization also means to me, and when you talked as well about the institutions that we have to manage and work through by mobilizing, I think that something that might pops up in my mind is there are so many issues around the world that needs to create connections, right? So there are many other causes that are not per se given the space that they need in a lot of institutions, right? So then in the legal field in academia, you can say, well, it's always attention from from the scholars given to the same 5 countries, or these are always taught in universities, right? And it's only when the students decide to go beyond and they find a professor that is willing to hear them out, which might not always happen, that there are these kind of spaces for broader perspectives and for legal mobilization that emerge, right? And so my question would be, how would you kind of deal with this issue that these are particular instances that may fail to create a broader network to support students and academics that want to mobilize areas that are not at the forefront of academia or at the forefront of an institution?
Yeah, I mean, Jeff, this point it's a really good one. It goes to Ava's point about the importance of having a diversity of students in your law clinic, because actually, if they're driving the intellectual agenda, you're much more likely to spot the sorts of issues that otherwise we might be prone to overlook or to forget. So yeah, any comments on that? I mean, it's partly what the Legal Mobilization Platform is precisely designed to address.
Certainly. I mean, our attention has been erstwhile to institutions of governance or corporations, the kind of usual suspects, so to speak. But in fact, the institutions that we're working in, the universities, also need to be critically examined. How it is that we sort of communicate amongst ourselves? How is it that we communicate to societal partners? And there's a whole lot of pressure to be societally relevant, but very little understanding within the academy as to how to interact with societal partners. I mean, I worked within these societal organizations for the best part of my career, and I can see what a huge gulf it is to try to have that communication between the academy, so to speak, and a societal partner. So indeed, the platform, a big part of that was to try to narrow that gap. But I think one of the most compelling points you made in your really very overall compelling statement was the role of students. And I have the privilege of running this course called Mobilizing Rights and Social Justice. And in that course, there's an encounter between students from Leiden University, who are mainly from the global north, and students at ISS, who were mainly from the global south. And that encounter is so dynamic, is so electric, basically, in revealing also, of course, the social and economic and other sorts of gulfs that exist between the global north and south, but allow for an opportunity for learning, not just legal learning, but of course, much more important, social and political learning. and it's been extremely inspirational for myself and certainly my colleagues in developing a research agenda. Students are always far further ahead than the professors who are standing before them in the classroom in understanding the real value of legal mobilization. And so I think it's incredibly humbling and experience, and indeed a huge privilege being a lecturer in a group of students who are asking these really difficult and important questions. And I think we need to continue these engagements. I think students are really framing the agenda much more sophisticatedly. So.
I'm going to draw the session. Do you have a question, Rana? One online, perhaps?
One last one that I
Great.
think is really interesting to raise.
Brilliant.
In the Nigerian context, what can be done by a mobilizer who is hindered by the law itself in the course of mobilizing the law to improve societal condition? An example of how the law can hinder mobilization that comes to mind is archaic laws of locus standi, which still hold sway within the Nigerian legal system today.
Might be difficult to answer because I'm not an expert on Nigerian law, but what I do think is, I've heard Azubike Anuora Oguno, who posed a question, and of course is a close friend and colleague of ours, and took over the teaching of this course. I was speaking about mobilizing rights and social justice. The work that Azubike is involved with at the University of Ilorin is truly inspirational in being able to have another platform, set of encounters to address the kind of questions that are being raised in this question. So yeah, I mean, I wish that Azubike was here in the room with us. I hope he was online listening to us. And I just want to use this opportunity to recognize the tremendous work that he's doing at the University of Ilorin and other parts of the world for that matter. He's also visiting scholar at the University of Toronto and is bringing those ideas also further north. That's really how I would answer that question.
Thank you for the question. It really relates to some of the discussion we had earlier in the first session about how we push up the fact that the grounds of standing are expanding, and where you know that you can make use. For example, the Constitution of Kenya now allows parties to be joined in an action as amicus. That kind of thing is being increasingly mobilized, including by feminist groups, by queer social movements and so on, to try and bring before the court, bring to the attention of the court particular issues. Try to, even if it means that you're laying the ground in a very preliminary way and that actually the fruits of this won't be seen for another decade, it's still worthwhile work to start to do. And it's taking that long view, and perhaps also teaching our students that long view. The outcome of this is not going to happen whilst you're doing your master's program. We'd love it to, but it won't necessarily. But what we're doing here is doing really, really careful work, laying the ground for future wins that we can hope for. I'm going to draw the session to a close by saying this has been really intellectually, really rewarding and enriching. It's a lovely way I'm officially starting my year today, because this is the great way to start the year, is to start it with this kind of conversation amongst all of you. You're invited to please do join us for drinks and for continuing conversation next door. I hope you'll stay around, because for me, this has really provoked so many further questions that it would be lovely to be able to continue to discuss. I think there are further plans for events, and already we have ideas about how those events might take shape and how they might look. So do stay in touch, but do please stay around now to join us for drinks and further conversation. Thank you all for being here, and particular thanks to our 3 panelists today, particularly to our 2 colleagues online for joining us. We very much wish you were here. And just so that you know, I'm booking a train to Cambridge to come and see you as soon as I possibly can. All the best. Thank you all.